know you are an attorney you work with us quite a bit, but also it seems like
I'm also in Blair, and which is Washington County, and Dodge County, which is Fremont. And so Douglas County can sometimes be seen in a bit of a vacuum because there's a lot of different services, a lot more meetings that are required. The smaller counties, the distance is a little bit harder, so there's not as many formal meetings as we have in Douglas. So I think that the two different perspectives is interesting in thinking about the permanency hearings and the TPR hearings and what we can get out of them, what you bring when you walk into one of them.
Excellent. So, and as I said, I can speak from the perspective of Sarpy County and Douglas County, and so you can bring in that flavor. And then also we have Marshall Johnson here, who has also been with the Justice Center, and he also works with us, so he can also answer some questions, talk about that, because the Justice Center also serves this upper area, okay? So, all right, so we're going to talk about the permanency plan, hearing conferences, and the termination of criminal rights conferences. And what we're going to do is we're going to say, it's been about a year, so we're going to look back and go, how's it gone? First of all, what are they? Because some of you may or may not know what they are, or you're using them, or you've heard about them but not had a lot of experience. So we'll flush that out. Then we're going to talk about, what's it looked like for the last year? What has gone on? Okay, what's the purpose of them? What's gone on with them? We're going to talk about a little bit of data. I wish I was as strong as Sarah with the data collection. I'm not a data person. However, we can show you that for a year we have collected data on these conferences, and you're going to see how they're really well received. So we will talk about that. Then we're going to talk about our lessons learned. What's gone, then we'll talk about the legal issues, some legal questions that may come up that you want to prepare for, you want to be aware of, the what ifs, so we can kind of clarify those questions that you may have. And then also we'll talk about lessons learned. What's gone well? What do we have to be careful of? And then hopefully this will be a kind of an interactive dialogue, and you can talk about your own experiences or say, what about this? How would that work in my area, or how have you experienced this, okay? So, and if I break out into song, we'll just all have to do it for a little bit, okay? And I sing as well as I do data, so it could be really dicey, all right? And I don't know. What do I click? Oh, there you go. Oh, there you are. Okay, so first of all, let me ask you, kind of get a pulse of the group. Do you have a lot of experience with the permanency plan, pre-hearing conferences, and the termination of rights conferences? Is this a group that's like, we're very comfortable, very familiar with them, or is this new information and have a new experience for those? Who has not, or does not know what they are, or has not experienced them?
I've had one.
You've had one, so you're just now dipping your toe kind of in the water.
It was Dodge County. I don't normally go to Dodge County.
Okay.
We don't do it in my area.
Okay, so let's just kind of give a real quick overview, and then others who have done that, if you have other insights or other input and a difference, please let me know, okay? Basically, permanency pre-hearing conference, ideally, it's court-driven. When your permanency plan hearing is scheduled, and so basically we would like to see those happen. The judges in Sarpy and Douglas County are liking to see those happen 6 to 8 weeks prior to that hearing, okay? And so that ideally is the case. And ideally what you want to do is you want to get the key decision makers at this conference. This conference is about a 2-hour meeting, and the purpose of this conference has a single focused question. And it is the permanency objective going to change? If so, why? And if not, why? And talk about the supports for both of those discussions, okay? So it's really about preparing for that pre-hearing that permanency plan review coming up, and it's about making sure, it's trying to minimize surprises. Okay, your key decision makers that you want to have present at this conference is going to be obviously your attorneys, and I also emphasize a guardian ad litem for a parent. That's absolutely necessary. Okay, you want to have the parents there; they have to be there. It's really important that they're hearing and talking and seeing and understanding that this year is coming up and what importance that means for their case. All right. You're talking about having the CFSS person there, and also the service provider there, because they are going to be the key. They're going to be talking about, this is what's transpired for this year. This is what's gone well, this is what's been a barrier or struggle, and what are we going to do about that, okay? So it really is about a 2-hour conversation of really focusing on what's this looking like, where it's going, and why is that happening. It's not a mediation. There doesn't have to be agreement there. But it's a discussion, it's a facilitated meeting about what's going on and how can we minimize surprises, how can we be prepared. It really is also a nice way to look at, were there any items, balls dropped? Was there items missed in terms of services? Was something that we thought was happening, wasn't happening, and figuring that out, okay? One of the things that the attorneys are really liking about this is that they're hearing about things that then they can say, okay, let's look at these next 3 months and really focus on, with their client. So it's really a win-win for the participants there that they are able to participate and be a part of what these next months are going to look like, okay? And to ask questions and clarify. I thought it was really important that the presenters prior to us, said it can be scary. And so one of the things that I often weave in these conferences, as well as family group conferences and other meetings, is tell us what you're willing to do, family, and tell us what you're not willing to do. Let's really talk about, let's really be realistic at this table and really talk about what you're not going to do. And why haven't you done it? Okay, why you don't want to do that? Why don't you want to do that? Let's figure something else out. It's really giving a safe environment to really open up and say, okay, here's what the years look like. Here's what the next few months are going to look like. Are you willing to do this or not? And it's surprisingly how comfortable and ready those parents are saying, okay, I will talk to you about this. Anything you want?
I think, yeah. I don't, from my perspective, when I work as a guardian ad litem and as a parent's attorney, these are not for every case. And I think we can probably think over our caseload and recognize when you're a year into it, there are cases I'm sure you can readily identify that are, where are we at with this? Mom's not getting it together, or the department's dropping the ball, or the kids are of such an age that really, we're not really looking at going home. Maybe they have their own issues and we need to be looking at an independent living program or something like that for them. And so it's just kind of looking over what the case is about and identifying why would we change something? Are we at a point where we need to change something? And I think the permanency hearings get lost for a lot of us. It's just a review, and a lot of times the judges will wrap them together, the review of permanency planning. We don't really talk a lot about permanency because we're all focused on reunification. But I think if you identify the case, where are we at? Are we kind of dead in the water? Are we just waiting for 15 months because nobody's doing anything? Do we need to wait? Those are the cases I think that are important to maybe sit down. And then also cases where you have older kids. Sometimes it's just not really realistic for them to go home, or they're getting ready to graduate, and guardianship may not happen for them, so let's make sure we put proper supports in place for them so they're successful. Also, who's going to be there? And that's something that you would work real closely with. We're lucky to have Lori, and I can pick up the phone, and she may have been given a list from the case manager of who should be at these meetings. We've many times altered course on that because there may be a family member that is just going to blow this out of the water, and you're not going to get your client to focus on what the real issue is because they come to the table thinking it's a mediation and let's air dirty laundry and let's talk about what everybody's doing wrong instead of why are we here? Focus. One thing, are we going to change the permanency objective? Is it really true? Can we continue working on this case so that these kids can go home, or is it really the case that what's the likelihood of this happening? And then, like Lori said, what are we willing to do? Because you've got this much time left.
And I think you bring a good point. It's a discussion when you're deciding who needs to be at that table. It's not like a family group conference. These have come out for a real specific need, and they're really, really effective. And so we very are careful. We want the decision maker there. We want the family there. We may not necessarily want all the relatives there because it can be distractive. And this is a very focused, a very efficient time spent for 2 hours. And so we may have a family person there to be a support, a moral support. But we really are careful with, we're not filling up the room right now. We're really focused on this is a serious meeting, and let's really make sure that we have the people there that need to really be talking, okay? We may have a therapist there or somebody from the service side. But because of maybe there's going to be a discussion about that service, maybe there's been kind of some controversy about it. Maybe some professionals thought the service went well and that the family was, productive and successful. And maybe there's some other information saying, no, it really wasn't. So we may bring that service provider in and say, okay, we need to talk about that. We need to clarify that. Again, making sure the information is shared and given. Making sure that, again, there aren't surprises. There aren't these situations where we go, I don't know, we'll have to check into that. So it's about, again, providing as much information, dialogue, and a plan to go forward. And you can have two different discussions. You can have two different focuses at the end of that meeting. Some, professionals are saying they want to do this with the permanency objective, and some are saying, no, we're going to do this. That's okay, but everybody understands that. Everybody has their ducks in order. Everybody knows what they're going to go do when they walk out that room and when they go into that hearing, okay? So any questions about these permanency plan review conferences? Okay, so then we also have a termination of parental rights conference. And these are scheduled, we get these when there has been a pretty decided discussion that yes, we are going to start looking towards termination of parental rights, or in fact, the motion has in fact been filed, okay? And these we do as soon as possible. As soon as that comes over our desk, we try and get them set, but it's prior to the hearing, prior to the trial. And again, it's about the key discussion, key decision makers coming to tables. The parents, has to be the attorneys, has to be the guardian ad litem. We also bring one other person into the meeting, and that is a relinquished counselor. Because the idea about this meeting is termination is sitting there. Termination is we're going that the case is going forward to look at termination. Are there any other alternatives you want to consider? It is not about coercion, it's about facts, it's about information, it's about finding as much information to provide the family so they can settle in and hopefully feel like, I'm going to think through this. I really do know now this is a reality sitting at the table, and I really need to kind of start asking some questions that maybe I didn't want to deal with to begin with. We bring that relinquished counselor in as information and as a resource, which is really kind of nice because it takes that burden of relinquishment discussion off the state, which sometimes can be uncomfortable or a little bit just, not knowing quite where to go with that. So we have the attorneys, we have the parents, we have the relinquished counselor, and we talk about what is the case ready for termination? And so it's a very realistic statement of yes, here are the facts, here's the basics of overriding this case. We talk about what's the termination going to look like, so the parent can actually vision what that trial is going to look like, what it's going to hear like, what it's going to feel like, what is that going to be like in their life and in their life as they view their children. We then talk about, okay, what's relinquishment look like? What is that? What are the emotional steps of that? What is the legal steps of that? What are the outcomes? What are the consequences? So again, the whole idea about this conference, it's about 2 hours, is to have as much information as possible to give these parents so they can start going, okay, do I want to consider this? And there's no force that some will sit there and say, no, I really do want to go to trial. I really want to fight this. Some say, I want to think about this. I want to reconsider this. There's some thoughts I didn't have yet. And so it just provides them that last arena of, okay, what else do I need to actually consider before I start marching down this path?
And it's not, some people have come into this with the idea that this is a mediation. We're gonna go over the facts of this case, and that case manager hasn't put these services in place, and that mom's not doing her treatment or whatever it is, and this is not the place to hash out the case at all. It's really, when I'm defense counsel, it's really the door opening for me to sit down and have, within the spirit of our music next door, we'll come to Jesus talk about this is where we're sitting here. This is what the state's going to present. This is where you may have not done so well. This is where you've done well. And maybe we'll be sitting there saying, okay, we're going to listen to what you have to say, and I am going to respectfully disagree, and my client's going to just sit, and we're going to go, okay, but now we know what the state's case is, and we'll go back and talk if we don't feel like they have enough to go forward with a termination. Oftentimes, though, if we're to that point, there's been so many issues through the course of the case. The writing's pretty well on the wall, but you're really spending a lot of time talking about, okay, if it's a termination, what does that mean for me if I ever have children again? If I want to do an open adoption, what is that? And that's not a conversation for that day, but that's a conversation that you can then use with your client later. Also, if there's family members involved with placement, if I relinquish and they're able to adopt, then sometimes you can get into, okay, what would a visitation plan look like? You can open the door to those discussions. So.
They're really individualized, and that's why it's really important with the key people being at that table. We do a really good job with prepping the people before they come to the table and talking about, here's what's going to be expected, here's what's on the table, here's the discussion, here's the focus, here is what's going to be discussed, here is what's off the table. And we will get that from the CFSS worker. Guardianship is not an option at this point. We're looking at this and this and this. So we let them know what to expect prior to coming in. The beauty of these is that they're fluid and they're flexible. We have had a case where guardianship was off the table. It was termination, relinquishment. We were talking through this because we had the right people at the table. We had the county attorney. We had all the attorneys there. We had the state. We had the provider. We were sitting there talking, and suddenly they all just kind of stopped and realized, they thought, maybe guardianship might be an option. They suddenly were hearing things, saying some things that they wanted to step back and go, you know what, maybe we are going to consider this. We have the county attorney there at this termination parental rights conference, and they were like, okay, maybe that can be considered. Step back, and they went a different direction. And so originally that was not on the table, and then suddenly it was like, okay, through this dialogue and this conversation, these questions, it allowed them to feel like, let's stop here and let's consider something different. So that was a very productive meeting for this family and for the professionals involved. They felt like this child, this family was going to have a really good, solid well-being. So,
And I guess with you bringing up the county attorney's presence, in Douglas County, that rarely happens, rarely happens. In Dodge County, they are always there. And I think you have to kind of look at just what your county practices in Dodge and in Washington. The county attorney is very involved from the inception of the cases, and oftentimes they're small communities. They have run cross paths before. So I don't necessarily always like their presence because I think sometimes there's some animosity between the family and the county attorney already. I do, though, think it's also important for that client to hear, this is where the state's at, this is why we are where we are, this is why I think I can go forward with this. So as you're implementing them, or if you're thinking about implementing them in your own counties, you might think about what the relationships are, and if that's a good idea for trying it out. Like Lori said, it's fluid. You can kind of craft this to what's going to work for your community.
and I think also one of the key things here, and it sounds so simple, but it's a really safe environment to really throw everything out there and talk. And that's what we really work to make sure that environment is like that, and that we facilitate that and direct that. And I will tell you, one case comes to mind. It was a PPR conference, and the case manager was new, brand new. They had had several turnovers in case management, and it would have been kind of tough. And this case was clearly, they were talking about going towards termination of parental rights. And this case manager, and you could tell, it was really kind of uncomfortable, but she had done her work. We started working with her and telling her what this was going to be, and she got prepared for this. And she came in and she said, I'm going to throw this out there. I want us to wait, because I actually have a whole different view on this, and I know I'm the third, fourth, fifth person in here, and I've only had it for a while, but I want to sit here and look at this. And you know what, after this dialogue, and when she talked about and went through all the information she had and how she put it together and talked about and really put that case on, they all sat back and said, okay, you know what, I think there is some doubt here, let's kind of slow down a little bit. So again, that was a very effective use of that time and say, let's figure this out. And so these can be, again, very fluid and very flexible. Any questions, any thoughts? Anybody doing something a little bit different with when you hear this overview of what they are? No? Oh, and the numbers, let's see. Oh, the numbers aren't up there. Sorry. We handed out a packet, and so I will tell you what you have in there. You have an overview of the protocols and procedures for permanency plan review conferences. You also then have your termination parental rights conferences. Then you have 2 sheets of paper, and they are evaluations that we hand out. They show the questions and the ratings for the year. And what we've done is we have compiled the data and the raw number, the number for the year. Okay. If you will look right here, it looks like the questionnaires. And at the end of the question, you'll see what the overall rating is for that overall period of June of 2009 to June of 2010, okay? And so what I have up here, which didn't get transferred, sorry about that, is that for a permanency plan review hearing case, the overall average satisfaction survey showed that it was a 4.7. So overall, when you look at all those numbers and you compile that, you see that out of a 5-point scale, 5 being the best, there is an overall rating. So we took into account the attorney's feedback, the professional's feedback, the parents' feedback, all the people at that table that we hand that to each and every time we have a conference. And the overall satisfaction is 4.75. So they're telling us they like these conferences. They feel like they're working. They feel like they're giving us an arena to do some work that we need to get done, okay? And then what I broke out specifically was the parental average satisfaction survey for PPHCs, for permanency plan hearing conferences, was a 4.67. So again, overall, you're finding these parents are saying, this was fair, this was effective, I felt heard, and I felt like I could ask questions and talk, okay? And you can look at those examples of those questions that we sent out. Also in my data that we had for parental rights terminations hearings, conferences, the overall average satisfaction for everybody involved was a 4.51. So again, really feeling like these are doing what they need to do. A parental average satisfaction survey was a 4.33. we kind of talked about why that dropped a little bit. You know what, I think you do have to face the fact that a termination of parental rights conference is really kind of it's a serious and it's not a happy event. I mean, it's very sad. It's talking about, the reality of what's going on here, what this is going to look like. So it really is an emotional and kind of tough conference. However, at the end of those, they're still saying, you know what, I think we got done what we need to get done. We talked about what we need to get talked about, and the parents are walking away saying, I felt like I was heard, this is okay. I feel good with this. And so I think those are pretty powerful numbers to see. We hand out the questionnaires, the surveys after each conference, and we have them on the table when they get there. And we've done it both ways. We tried to send them out. We wouldn't get them back. It's just too hard. So we just have them fill them out right there on site at the end of the conference. And so we've been very successful to get most of them back. 99%, sometimes they'll walk out the door, and it's been it's helped us to really look at, are we asking the right questions? Are we really getting the information? And does the family feel like they're a part of this? Are they hearing what needs to be said? And are they actually feeling like that they can actually talk and give their information back? Do you have any?
No, I would just add that I think part of the success probably comes from, sadly, it's one of the first times I think that the focus from the minute you walk in the door, at least when we do it at the Concord Center, this is about you and the Smith family. It's not about, we're here to tell you what service you're supposed to do or evaluation you're supposed to do. And the caseworker really has kind of a backseat to the facilitator, which I think is probably lending itself to a more comfortable format as opposed to, being dictated to what they're supposed to do to get their kids back.
I was talking to Kelly and she laughed. We were talking about when these first were kicked off last year at the regional conference that was going on there, and we were talking about it was very exciting. I come from the arena of family group conferencing. We do a lot of different types of facilitations, and what we were seeing is we were seeing that families and case managers back then were trying to bring a family to the table in a family group conference kind of setting, but they still wanted to talk about, it's been a year, they still want to talk about, hey, it's going to be terminated on, what do we do about adoption, trying to really kind of squeeze that. So when we heard about these coming out, it was just so refreshing, we were really excited. Kelly, coming from her side, laughed and said, are you kidding? Another meeting that you want me to be at, and you're talking about 2 hours? Let's face it, that's a long period of time. And as you mentioned, up in this area where you're traveling to get to that meeting, then it's 2 hours traveling back, and it was just a kind of an overwhelming, you've got to be kidding me. One more conference, one more menu of services and meetings that you can give me. You know what, but then we looked at that and again really remained true to what the purpose was, what the protocols were, and as we get this feedback, we're seeing that people who participate in these, the professionals, the attorneys, the families, saying, you know what, we like these are working. We really, really feel like we're being heard here and it's going in the right direction, and the information that needs to be out there for us to do our jobs is right there. So that I think is a very positive statement.
Well, yeah, I think that when you look at, there's a reason why we practice in the areas that we do, because we can't be everywhere. And so, and we have lots of families to deal with and lots of other commitments, but that's why I feel like there are key families that you can hone in, that this is something that we should sit down and do. And I don't really find them, I wouldn't find a PPR or a pre-permanency hearing conference very productive if I've got a mom on the right track and she's just about ready to get her kids back. And there's no need to do, I don't think there's any need to sit down and do that at that point, because we all know where we are. Now, the cases where you're kind of like, where are we here? Those are the ones to really focus on. And then, of course, we make time and we figure out, you could do it over a conference call. You figure it out if everybody's there. There's a way to do it.
And again, that's that flexibility. We've had them come to us, and it has felt like this would really be redundant. It feels like as we talked to all the participants, they said, you know what, we do understand. We all are in agreement. We know what's going forward. We would rather not have this. As long as they're willing to kind of say that up front in the court, it's like, fine, that's great. We don't want to waste time. We don't want to put people through hoops. This isn't what that's about. It's about making sure that they've been provided that environment to be able to do what they need to do. At the same time, we've also had, attorneys call us saying, we really would like to have one of these conferences because I feel like maybe it's not getting done right now, and I just want to make sure, can we get this done? How can we do it? So we get it from both ways, but the idea is, it's not about just adding one more thing to everybody's checklist. It is about truly how effective is this going to be, and is this going to work, and is this, is this necessary? So absolutely.
Or, as an example, I'm thinking of a case with our 3 teenagers. That might be a good example, because they were all slated for guardianship. They're teenagers. It wasn't going to happen. and they created their own plan.
Oh,
So
that's
each
right.
of them came up with their own plan
Mhm.
as far as, I'm going to be done with high school, I'm going to college. And so the conference was basically spent, okay, so your PALS worker is going to do this with you in this amount of time. And then the follow-up was making sure that those things got done. But I think those teenagers get lost
Absolutely.
very easily, and then they're out of high school and on their way, and no one really has a plan for them.
And
to make
time
them
slips away.
successful.
It's not a judgment on anything other than time slips away, and these kiddos are getting to be 17, and nobody really, I mean, you've got some ideas. Gosh, you know, things have just gotten ahead of the horse, and you're like, okay, I thought we were gonna, and we haven't. What's gonna happen? So it really is about really getting to that meeting, being very specific, and attaching names and dates and timelines and responsibilities. And the kids walk out feeling much better. They feel relieved.
It's their case.
Absolutely.
It's my case.
Absolutely. What other legal issues have you seen that you feel like the group should be aware of, or you just have heads up about? Or?
Just, it's not a mediation, we're not there to hash out the case facts, and I think that's something that the clients often have to be reined in about, because they want to talk about how poorly the caseworker's doing, and that it's not their fault, or what's not getting done, and that may be true, and that may be part of a conversation, but it's not the crux of why we're here. I know that defense counsel often is very leery. If they're going to fight a TPR, they don't want to have their client divulging anything. It was always what I hear, but generally speaking, we kind of all know where we're at with this. And so I haven't come across any earth-shattering news that has made or broke a case. But and there's been times where they'll just sit and listen, because that's fine. You're going to tell me that you want to terminate and we disagree, and we're not going to otherwise do much more than listen. But then that gives you information to go back and have a conversation with your client. So I still think it's worthwhile that way.
And that misunderstanding that it is mediation just lingers out there, because you even had another attorney say, why would I come and agree to anything? Well, it's not about that. It's really about just kind of having that dialogue and sharing information, making sure, okay, we're aware of where everything is going, so I know how to go back and then prepare or be ready for or ask the next question about. And so I think that's something that we're constantly having to re-educate about, because the first words are, why would I do that? What do you mean a mediation? What am I going to mediate? I have my plan for my client. So that's, I think that's just something we're going to constantly have to go over time and time again. So I guess probably the idea about lessons learned, what are some things that we have felt that were strengths, and then some things that we felt like, these are stumbles, or these are things that you just have to be very careful with. And probably the strengths, and one of the things I see and I hear from the CFS worker and the service coordinators are, this was a safe environment. It helped me to really get things in order and to be prepared and to really present information and be able to stand up and back that information and really have a good, dialogue. And I felt like it could be a really even and fair conversation, And they know that we have everybody's back in that meeting. As facilitators, we're there to keep the meeting going forward, not to get into, the mudslinging and it's your fault and this fault. Say, okay, what has happened? What needs to take place? Who's going to do that? What's going to be the next step? So it's about really having a safe environment. And the CFSS workers and the service providers have said, you know what, it feels really good being able to do that. And it really allows them to do their job as well as they possibly can. So that's something that we've really seen. Have you experienced?
Yeah, I think it takes them out of the hot seat as far as, they're kind of not looked on very well. You took my kids. I don't want to hear what you have to say. You just are trying to make life hard for me. And this way you have Lori, or the facilitator, there asking the questions. It's not the client being peppered with questions, or the caseworker being, in the spotlight as far as why haven't you done a referral. So.
And it's about minimizing those surprises, minimizing that you've got to be kidding me, really? And so then having everybody get that look on their face and think, what now? It was during one of our conversations, one of our conferences, it was a permanency plan review conference, and however it had a determination flavor to it. It was getting ready to go towards that. They were talking about that. That was something that they would want to change the perspective or the objective to. And as we talked, one of the statements, there were 3 fathers, and there were like 7 kids, and one of the dads was from Chicago. And he was there. He had just been, he just found out that this was all going. So they had sent off the provider, or CFSS worker, had sent off a home study just within that last month. And their statement was, we said, what is the goal here? What's happening right now? They said, well, we're going to work towards these 4 kids going back to dad for reunification. We've done some conversations on the phone with the worker there in Chicago. We feel like this is a really strong possibility. It looks great. They've made some steps towards that. They said, however, if the home sale doesn't come back in time, we're going to recommend termination of parental rights. And I kind of went, okay, help me out here. I'm not an attorney, but that doesn't seem to be on the same, I said, okay, so you're at two ends of the continuum here. I said, so if dad is okay and you're working towards that, but if a paperwork issue doesn't come back, you're going to terminate parental rights. And then my next question was, okay, when did the home sale get done? Who followed up on that? And it was silence. There was nothing there. And so it became very apparent of what people had presumed people were thinking. And it was just kind of a stopping of the conference moment. And so as they would talk and flesh that out, it suddenly became aware there was a lot more work that needed to be done, a lot more figuring out what had to happen. And when they went into court, things completely changed. And so I think those kind of moments that brought that out, where people were just marching forward, and it's like, okay, wait a minute, what about this? Did anybody ask about this particular date and when this was done? And so I think that's really important. It takes those surprises and those, oh, we have enough of those, so we don't need to make any more of those for ourselves. And I think attorneys really appreciate that. They appreciate knowing what to expect and knowing what their next questions are going to be. Let's see, what's kind of nice also is I think a strength for this is that the family is getting one more chance of a voice throughout that case, throughout their case. And so they're able to feel like they are, as you said, the focus. They get to be the middle of this. And it becomes, we really work hard to make that safe environment. That doesn't mean that they don't get those opportunities in other places, but this is a time when they sit down and it's, okay, tell us again what you're going to do. Tell us why you're not going to do it. And and they surprisingly they really do open up about that. They really start sharing some information because they feel like they're being heard. They've got the right people there, kind of listening to them and asking questions. And so it's a one more opportunity for them to go, okay, you know what? I really do have a say-so on this. I get to have a say-so on my family and my kids. This is court hearing driven. This isn't one more arbitrary meeting that sometimes we have. This is driven by hearings. This is driven by a process. And so it's has a reason for it. They're very focused, is very efficient about it, and so it doesn't get off on different, sometimes we go to meetings that kind of take a different turn, or suddenly you're thinking, why am I here? These remain true to what that purpose is, and it's wrapped around what that hearing is going to be that's marching up in the future, okay? So I see that as a strength. You can see the outcomes. The outcomes are saying the professionals, the attorneys, the families really, really like this. They want this and they like it, and they really open up during these conversations. So even though it's one more meeting to go to, it's a really effective and efficient meeting, I think, for all those participants, family and professionals involved. Do you have anything on the strength side that you want to?
I think it's a strength that it's reality. This is really the reality of the situation and where we are, and this is what it's going to look like if you're TPR'd or you relinquished. This is what happens after we all fade away and you're left with the family, and I think that's sobering for some of these families. But it also opens the door to be able to talk about, okay, so where are we really, where are we going?
So then on the concern side, and not necessarily concern, just a matter of, okay guys, watch out for this, be aware of this, think about this when this happens, okay? Bringing children, especially to the termination of parental rights conferences. That you want to be careful about. You always want to have the children, if they're older enough to participate, you want their voice in there, okay? But you also want to be very careful because of the way this is being structured. You want to be careful, and you may make sure that you plan with them, and that maybe if they're a therapist, they plan with them. They prepare them for what that dialogue is going to be. So we're very, very careful about that, okay? It's really interesting. One of the very first termination of parental rights conferences we had, right out of the pilot project, we were really excited. It was a huge conference. And we actually had the child come, and he was about probably 10 years old, and all of us were like, okay, we wanted to be very careful with this person. And he was a very clear, a very articulate little boy, and knew what he wanted. And they had posed the question to him, he knew what was going on. He knew where this was headed, and he said, I want to be there, and I want to be able to talk to my mom and dad. And his adopted family, his potential adopted family was there, and he'd been with them for several years. And so he was able to come to that table. And that was a pretty powerful moment for those parents, because he was able to look at them and say, I love you, but I don't want to go home. I never want to go home with you because you can't do it, and I need this. However, I love you, and we can figure this out. And it was amazing. It was pretty powerful. And those parents heard that, and it kind of moved that case along, at least, what they were realizing at that meeting. So just be careful. There's no blanket statements that it can always happen or it can't happen with children. Just be very, very careful. Again, what's beautiful about this, it's individualized. Put the individualization back into it and figure out what's going to be the most productive, what's going to be the best for these little kiddos, for their well-being and their permanency, and for them to blossom and go forward. And that's kind of what we're all here about each day. Scheduling and timing, that's really critical. Ideally, you would like to have these conferences come about 6 to 8 weeks prior to the permanency plan review hearing, obviously prior to determination of parental rights. And so that doesn't always happen because of timing. It's just really hard. Two issues. One is everybody's schedule is really tough, and it's hard because you have to have the attorneys there. You have to have the guardian ad litem for the parents if they have those there. You have to, you invite the county attorney to the TPR. You're getting that foster family there to have input about the child and the parents. And so that's really, really key, and we're struggling with that. Also, we're struggling with the fact that by the time the order, ours are ordered in Douglas and Sarpy County, we're getting orders for these. By the time that order gets to the desk, the service provider's desk, who's going to arrange this and kick this off, a lot of time's gone by because, gosh, it takes time to do the order and get in the mail, and then it takes time, to kind of sift through all the stuff that's on everybody's desk. So that's been really difficult. What we have done to try and circumvent some of that is that we've been getting the orders immediately, and then we pick up the phone and call the service provider and say, hey, you're going to be getting this. We fax over the order to them, and then we started going that way. But, it really needs to be 8 weeks. It would even be ideally 12 weeks prior to the permanency plan review hearing, and obviously like 12 weeks or so out for that termination of parental rights hearing, to allow for the professionals to be there and to do and to ask questions and then to get things in order that they need to get in order. Any thoughts? Or?
I think that the more time you have to plan, the better. Would be the only thing to make sure you're thinking about with that. Because, when we first started these, there was so much time spent on it. So what's everybody's strengths and what's this? And we would sit there and say, we're terminating. So why are we talking about how they're going to fix this when we're at the end of the line here? So the earlier you can catch it, especially if there's any hope that you're going to be able to salvage the case, the better it is for the family.
Also, a key issue is prepping people's roles, what this is for, again, getting back to what the purpose is. It's not a mediation. What's the discussion here? What's the purpose here? So that people know what they're acting like at that meeting, what kind of role they're wearing, what is going to be discussed, and how they can respond to that. Because if they come and think it's going to be a mediation, they are really against, something. Or if they feel like they're going to open up this whole dialogue about other things, well, you know what, again, that's not really fair if that was their expectation. They come to the table like, what do you mean this is really going to be about this? So we really do a lot of work with, hey, this is what this conference is about. Here are the questions. We actually send out the questions in this packet that you were given. We send these out to people who have not done these before. We talk about, here's what it's going to look like. Here is about kind of the questions. These are the parameters going to work with them. Now, again, some of these will be flexible and they may look a little bit different, but this is where it's going to start, and this is what you can expect. And that helps that this, again, remains true to what the process is, remains true to what that goal is.
I think it's important who's there and who's not there.
Mm-hmm.
Certainly, there's sometimes when you may always have a family member there. You may always have a foster parent there. The foster parent that might not be appropriate. There may be too much tension. However, we've had cases where the foster parents can do a guardianship or adopt, and then the parent can feel more comfortable and talk about, okay, well, what would, if that did happen, then what kind of visitation would we have? What would that look like? And that's very helpful for the parent.
And to build on that, again, that allows us to make those decisions with the work of the service, the case manager and the service provider. We had a case where the family came, we had it set out to what particular people were going to be invited, and then about 5 other services providers came, professional service providers came, and it was because they were very angry that this case was going in one direction. They just felt it had to be fair, and this is not right. And so, we did a lot of talking with them, and we did have them come in. Because we felt like, first, their information, the data that was necessary, the key information was with the case manager and was with the service provider. And we felt like that tension and that kind of taking sides was not what this conference was going to be about. It was really about sharing that real clear information. And so we did a lot of talking, we explained what the purpose was. We also let them understand that the CFSS worker did have their information, did have their reports, did have good, clear information. And so they felt like, okay, you're going to give that information. But they really want to be in there just to kind of root that family on. You can understand that, these families, we all need rooting on, but this probably wasn't that meeting for that. And so we had to have them leave. And, they understood that. We had to continue to have a good working relationship with those groups. But, we had to make that stand and say, this isn't going to get us to where we need to be at that point. So. Okay, so any questions, thoughts? How are you handling them in your areas? Are these, you said, I don't want to pick on you right in front, but you said you had gone to one, you were thrown into one by accident, or was it your area?
Well, it originally, The case originated in Dodge County, but then the mom lives up in our county and the kids were placed up in our county. So then we ended up getting the case transferred to us, but the court case is still in Dodge County. So then they, and it was coming up to that 1-year mark. So we got the invitation and I went with my worker because we've never been to them before. So she asked for me to go as well.
And was your experience, do you have anything that you'd like to add to say, boy, it would have helped if I had known this, or boy, this was interesting to me, I'd like to see.
I took a lot of notes, and I had my own input. It was a nice meeting. There was tense moments and everything because the mother was thinking a certain way, and we were thinking a certain way, but then when the guardian ad litem made her point, you could see where she was coming from too, and the county attorney, and we all left there knowing where we were gonna go, so.
Okay. So are you glad you went? Do you feel like it was a good use of what you needed to do?
Yes,
Whatever role you were in?
yeah, and it definitely did last probably about 2 hours. There was a lot of conversation, a lot of note-taking,
Right.
and it was well worth the time.
Okay.
So.
Yes.
How does this meld with like the team meetings that are held every month?
Mhm.
Because it just sounds like a lot of the information that's being going through at this 2-hour meeting is something that is regularly discussed at those team meetings that happen every month. How does this either meld with that, or how do you deal with that?
And I think that's a really good question, because those team meetings are wonderful, and they're very effective, and you're getting that information month to month to month. However, from what I've experienced, is I think there's 2 key factors. Those team meetings don't always have all the same people at the same time. Some people can be present for one team meeting, not the other. And so it really is forcing the issue of the key decision makers are there to hear what needs to be done at that moment, okay? The other piece of that is about that neutrality piece. And that sounds so simple, but it is so powerful. That neutral piece that the facilitators play, that we are able to step back and get the people there to facilitate that meeting, that amazing, sometimes when a team meeting is being handled, I know you're having to wear 2 hats, as the CFSS worker, as well as the, the team runner, the facilitator yourself. And sometimes that's hard. That's hard to do, and we'd like to take you out of that and put you as a participant in the meeting so that you feel like I get to really participate and share everything I need to do, besides having to gauge what's going on in that meeting and read the emotions and figure out what my next question is going to be, okay? And so also there's a perception, and the perception is about fairness. And we can all try and be, if we're working on a case, as neutral as we can be. Your heart's in the right place, your mindset's in the right place, but there are still those buttons that aren't making us neutral. And secondly, families may not perceive you. They still see you as the person who has my child. They still see you as, yeah, but. And that's their perception. And so that's really hard to work with. And so, again, we add that layer of that neutral facilitation piece, that neutral person saying, okay, we're here, and our investment completely is only about keeping this meeting safe, keeping it focused on the goal, and keeping it about what the agenda is, okay? And I don't know all the other stuff that has gone on in your family and has gone on with these hearings. So that's why it puts me or our facilitator as neutral in a really good position to ask those questions that sometimes we're like, oh, or maybe they forgot, or because we don't know, so we're always filling in those pieces and asking. So I don't know if that answers some of your question. And hopefully it's coming to a culmination of decision there, and it feels like it's effective. So it's a culmination of all those team meetings.
I think
So
the
good question.
team meetings are so focused on putting out fires. What's the next thing? Is this evaluation being done? Is that done? How are the visits going? And we lose sight of the bigger picture. Where are we going? How much time have we been spent getting there? So this is just very narrow. You don't spend time going over what services are needed or what was offered or what wasn't done. It's really just more bottom lines, this is where we are. And so then from there, you're talking about, is it possible to continue working, or is it something that the county attorney is going to file, and this is the route we're going. So you're not talking about that day-to-day stuff, and it's just really the focus on the end of the line as far as permanency, one way or the other.
And I guess that leads to my next question then. You had mentioned before about with the termination of the meetings, getting the information and things like that. And maybe this is just something that happens here in Madison County, but it seems like when there's the termination filed, we're able to get a hold of the caseworker notes and things like that, and get all of that information, be able to sit down and have that coming to Jesus meeting with our clients. And I guess with that type of information, what benefit would there be to that pre-hearing conference? I guess I'm just kind of everyone I hope would be on the same page and be available to the same information, sitting down and beating the mom or dad or whoever it is over the head with it again, rather than doing it as an attorney-client or something like that. I'm just kind of struggling with.
The majority of my cases, I don't need to do this because I know where it's at. Everybody's on the same page. There are cases though that, why can't we do a guardianship? The case manager says, no, we're going to terminate. I mean, those questions, or especially with the teenagers, they're very helpful. The permanency hearings or meetings are very helpful for them because you lose focus with, you're trying to do services for the parents or just make sure they're in therapy or they're going to school. You don't think about where they're going to be in 2 years and what do we need to do for services. But you're right, and especially when I work with Dodge County or with Washington County, our working relationships are so good with our caseworkers, and they do such a great job that there isn't a lot of questions. I think that they're more helpful for me at least, in Douglas, because there's so many people. Now let's throw in service coordinators. Now let's throw in all of these other people, and nobody can talk to each other. That's sometimes why it's helpful to have everybody at the same place at the same time. But you're absolutely right. Not for every case, and not when you have everybody's on the same page.
And you know, I'm fine because you do get to beat your client up and say, listen, you know, we're going to really have that come to Jesus talking. This is what needed to have happened. However, that's not what this is. It's really about, we don't spend a lot of time about this is everything that happened. We're going to go through every single service. It's there, it's to discuss. But I can tell you often these conferences, there's always a, that's not right. That's not true. I didn't do that, or you did do that, or I've got this documentation here and nobody took it. I mean, so then there is clarification because it's about that perspective. And when a family also hears all the different professionals kind of addressing that issue in a perspective that they can all hear in different words, suddenly it starts resonating with them. You know, but I've rarely seen it where all the information is, yep, that's right, I agree, it's all done, it's fine. It's like, that's, you know, and that's why every once in a while we will bring in then that particular service that really has been a contradiction or has been kind of just caused a lot of tension and really had a lot of yeah, buts, what ifs, you know, gosh, things dropped off, they didn't, they got back reinstated, they were re-referred, it took forever, how does that count against me? It's that kind of conversation. But you're right, it would be, I think, very punishing to the family. It's not what it's about, nor is it very productive to sit there and just go, you know, literally go over the same information time and time again. It's really about kind of taking that big picture back and going, okay, what is an outlier? What is the information here that's really causing a barrier or is going to cause a, okay. So
I think also when you aren't getting the caseworker and the family has run their course and they're not getting along anymore, I really do think bringing more in that's really what's helpful because we're done talking to you, you're not helping us, and nobody wants to talk anymore. I think that's helpful.
but we really do like you. Yes.
Okay, do you find that your clients that you are doing this with are some of your top cases, or are they?
Yes.
I mean, is the success rate for your tougher parents?
We've had that actual statement given to us on several different levels from 7 different arenas, saying, and we see this with family group conferencing, and we see this with the TPRs, we see this also with the pre-hearing conferences. We hear them say, we're going to give you these really tough ones. We don't know what to do. We're kind of, this is a problem, you know, we're kind of stuck. So they are actually verbalizing that. We are giving you the worst that we can give you because we are kind of like, we don't know what to do with this.
Yeah, because I work with Big Book in Stampede, and with a mother who she's lost. This will be her 3rd set of kids. She's almost ready to have her parental rights, you know, removed.
So she's lost her other 2 sets of children also through termination? Okay.
And, you know, I don't know. I don't know if she's serious this time, and so far she is, but
Serious in terms of reunification or serious in terms of relinquishment or serious in terms of?
serious in terms of staying away from all that. You know, guardianship. You know, because each case, each set of kids has had different circumstances. So I was just wondering if your success rate for people like that are, you know, a lot better.
And our success rate, I would say, is deemed about do we feel like we covered all the information? And do we feel like we allowed everybody to get what they need to talk about? And they actually walked away going, you know, this is helpful. I really feel like I know what's going on. I know what my next steps are. I know what I'm going to talk to my client about. That's how I would view success in terms of, I don't know if you're saying getting her to do a certain thing
No,
or.
I'm just, that, yeah, she has more of an understanding.
More of an
and
understanding.
Was happy, they were happy that, you know, they came to this and.
Because we also do some prep work prior to this. We are actually doing some case management with the families that are coming to the table. And we're explaining to them, this is what this is what you're going to be expected to do. Here's what's going to be asked of you. Your attorney is coming, you're going to have your attorney right next to you. We really paint that picture right then and there. They start asking questions. Now we're not answering all that information because we say those would be good questions to talk about with your attorney. Those would be good questions to bring to the table, okay? But suddenly they're already starting to have time to mull this over, and it's in an area where they can hang up, call back, and say, okay, now I have another question. I mean, so it really is giving them some space to figure stuff out. And so that's, again, what we're seeing on this data is like they're saying, I felt like you heard me. I felt like I was able to say what I needed to say. It wasn't a happy time. It didn't feel great, you know, but they felt like they had their information set. So, good question. Anything else? Any other questions? The 5-minute rule is coming up, so I can beat you to it. I think we're done. So thank you. I appreciate your time. And if you have any questions, please get a hold of us.
Lori, if I could just say, the Nebraska Justice Center, serves this area, and Jane just wanted me to be present and say that, again, like always, we're interested in working with the local courts, working into your system, working with service providers out in, if we got to go to O'Neill, we'll come to O'Neill. If we got to go to Ainsworth, we'll go to Ainsworth. If we're coming to Madison County, we'll come to Madison County. Most of the experience in the Nebraska Justice Center right now is in Dodge County because they were the first one in our service area to begin to use this, this service, have these meetings. So again, we've got people who can do it. We have people who are trained, who will be out here.
Thank you.
Sorry, I do, can you just explain the funding? Do they have to pay for it or is it grant funded?
Well, as I understand it, it is grant funded until the grant runs out. And it's been so successful in different areas, and courts are using it to such a degree that that grant funding is coming to an end. When that comes to an end, then there are ways in which judges have these ways. I don't understand all the mystery, that when things get court ordered, they happen and they get paid for.
What we've experienced in Douglas and Sarpy County is that we have utilized the grant. They are a per case rate, a flat rate, and so we've been fortunate enough that we have been able to access that grant. There are just a few more cases available left, and we've just been having conversations and discussions about that, about possibly looking at another grant, furthering the grant, adding more monies, whatever. However, that's not guaranteed at this point. We have had great success because we are seeing the service providers like KVC, in our area it's KVC and Nebraska Family Collaborative. They are very willing to pay for this. And so we have had that discussion with them, very upfront and transparent. We have money to do it for you right now, so we don't have to bill you for this. However, at some point, probably by the end of October, we're probably going to ask for a bill for this. And they've been great about it. They've been absolutely fine. They have been very open and workable because they have liked what they've seen with these. They've been very supportive. So, so far, that's how it's been going. So, okay, good question. Thanks, Kelly. Thank you.